Flashman, any reply you'd like to make?
Yes, Your Honor. A number. Let me start with the issue about what we're dealing with today and what's for the future. And as you're aware, the complaint is both for writ mandamus. It's also for declaratory relief. It's also for injunctive relief under Code of Civil Procedure 526A. And really, when you read through the complaint, of course, each of the causes of action incorporates everything prior to it by reference. So essentially, all of those are rolled together into each of the issues in the complaint. Each of the causes of action includes all three. Now, we are only prosecuting today two of those mandamus claims because, frankly, those are the only ones we think right now are right. The complaint also raised issues around that second funding plan that hasn't been issued yet, where basically they were made essentially towards the future and sort of saying, well, if these are right at the time we bring them to trial, we'll bring them to trial. They aren't, and so we're not. In terms of the 526A action, we think all of those issues are going to be addressed in the 526A action. So to the fact that we're not addressing them in the mandamus causes of action, it simply says, yes, we're not seeking mandamus relief on those particular, and if you want to say they're abandoned, I suppose you should say they're abandoned because they're not right, and they would be dismissed if we didn't abandon them, because they're not right. So we're not going to try and try a claim that simply isn't going to go anywhere. But that doesn't say that those particular issues are dead. It just says that they're not right for adjudication as mandamus claims. And we'll be coming back to them as you pointed out. There's a whole question of, well, where we go from here. Once we've dealt with the mandamus claims, then that's to be decided when we have our case management process. So I suppose we'll wait to hear what you say about these mandamus claims, and then we'll talk about what happens next. But certainly premature to be starting to talk about entering a judgment of any sort. In terms of the funding plan issues, I think there's a good question that you asked, and that was, why was it put on the ballot? And it's important to realize that the legislature passed a bond act that was much larger than what was put on the ballot. Not everything that was in the bond act was put on the ballot. And if the only purpose in the funding plan provisions was to provide information to the legislature, there would have been no reason to put it on the ballot. Essentially, they would be, by that part of the statute, they would be essentially telling the authority, we want this information, you tell us what we want, and then we'll be satisfied. But they didn't. They put it on the ballot. And why did they put it on the ballot? Because they felt the voters needed to know about it. And why did the voters need to know about it? Because it was part of the provisions that were intended to provide the voters with assurance that this was going to be done very responsibly. These were protections for the voters as taxpayers, because the voters were approving a bond measure that was going to be issuing bonds that they were going to have to pay for. The taxpayers are going to have to pay for. And these were assurances to the voters that, don't worry, this is all going to be responsibly done because we're putting in these requirements. And these requirements need to be complied with, and you don't have to worry about things being done improperly because all of these requirements are mandatory. And let me quote from the respondent's opposition brief. To allow the legislature and state officials the opportunity to provide financial oversight, not just the legislature and state officials. The Bond Act imposed limits on the authority's ability both to request an appropriation of state funds from the legislature and to spend funds previously appropriated. So essentially what they've admitted here is that the Bond Act restricted when the authority could go to the legislature for funds. And that was precisely the purpose of the funding plan. That was the restriction. Basically what the legislature told the voters and the authority was, here's the funding plan. You need to complete this funding plan. It has to include the elements that we're identifying to be included, and you have to complete it successfully before you can ask for an appropriation. And I think the answer to the question, well, what's the remedy, is if they didn't successfully complete the funding plan, they were not entitled to ask for an appropriation. And you asked also about, well, what's the funding plan? What about these requirements in the funding plan? And respondent's answer is, oh, well, it was up to the legislature to determine whether it accepted it or not. So what if the authority had simply submitted a funding plan that consisted of 7 words? Trust us, give us lots of money. It wouldn't have satisfied any of the funding plan requirements in terms of certification. Would the legislature be allowed to go ahead and say, oh, okay, here's $10 billion, because you're asked nicely? I don't think so. I think that would have subverted the whole purpose of putting the funding plan provisions not just into the Bond Act that was approved by the legislature, but into the Bond Act that was approved by the voters. When they put it before the voters, they were essentially making a promise to the voters. They were promising that this is how it's going to be handled. And the voters approved the Bond Act based in part on those promises. And those promises are part of the contract. And I think they're just as binding as any other contract provision. And the authority cannot now say, oh, well, that wasn't intended for the voters. If they put it on the ballot, it was intended for the voters. If they didn't want it included on the ballot, if they didn't want the voters to be able to rely on it, they shouldn't have put it on the ballot. You actually also raised another interesting and important point about the environmental certification. You pointed out that whereas most of the provisions in the first funding plan carried forward to the second funding plan, the environmental certification did not. And the question is, why not? And I think the answer is because the way the environmental certification requirement was phrased in the past tense, there would be no reason to put in the second plan, because if everything had already been certified, had been satisfied, all of the clearance had been obtained before the first funding plan, why was there any reason to ask anything more in the second funding plan? Everything's done. Well, by the authority's interpretation, everything wasn't done. And if that had been the intent, then there would have been a requirement in the second funding plan. The other point that I think, again, is raised by that question is, what's the purpose of that requirement? Now, the authority argues that they're required to have all of the environmental clearances completed before they go to construction. That's law regardless of Prop 1A. So the question is, well, if that's already required, why did they put it in Prop 1A? That language would have been superfluous. There would have been no reason to put it in the funding plan, to put it in the ballot measure. That can't have been the case, because again, as we know, when you're interpreting statutes, you try and give meaning to every word in the statute. If all you're doing in this provision is just doing what the law already requires, that provision would be superfluous. It has to mean something more than that. And I think what it has to mean is the fact that it's requiring it not when you go to construction, but when you certify the funding plan. When you say, we want funds, at that point, basically what the voters were said you can demand, and basically is demanded, is at that point you have to say, we're ready, we've got all of our clearances done. You don't have to worry about environmental clearances stalling things, because we're done. And the certification that the authority made doesn't satisfy that. It doesn't give that assurance that you don't have to worry anymore about the environmental clearances because they're all done. They weren't all done. And that didn't satisfy the requirement of the funding plan, didn't satisfy the promise to the voters. And essentially, their interpretation would make the promise an empty promise, which again is something that you don't do in interpreting a statute. One other thing, and that has to do, and it really sort of ties in with this whole question, both of the funding and the environmental clearances, and that is, what was the purpose of saying you need to know where the money's going to come from? You need to know you can complete it successfully. And there is a separate provision, and that was provision D under that same set of requirements. It says the plan shall, and by the way, it says the plan shall include, identify, or certify to all of the following. Now, it's identify, include, identify, or certify. They're in the alternative, and presumably that means as appropriate. And subsection D under that is that the plan shall include, identify, or certify the sources of all funds to be invested in the corridor or usable segment thereof, and the anticipated time of receipt of those funds based on expected commitments, authorizations, agreements, allocations, or other means. So now, again, it's left unclear whether that's just identification or whether it's also a certification. But it's clearly asking the authority in the funding plan to say, show us the money. Or at least show us where the money's going to come from. Maybe you don't have it all in hand, but show us what are the commitments, authorizations, agreements, allocations, or other means that you know you've got money that's going to be there. And again, I think that ties in with the provision that subsection G says that the corridor or usable segment thereof can be completed. You take those two together and it's basically saying you need to show us where is the money going to come from. And again, the funding plan really acknowledges they don't know. You know, it says, well, we've got funds here, we could maybe have funds there, possibly could get some funds here, we'll get some funds in the future there, but we know we won't get them now. That's not what the funding plan required. And they didn't satisfy that requirement. And the reason for having that requirement is precisely so you don't end up with a stranded asset. And one of the things that the authority in their revised expenditure plan, 2012 revised expenditure plan of April 2012, they said, well, if we don't complete this, we will essentially convert what we built into an Amtrak segment and hand it over to Amtrak, and Amtrak can use it for conventional rail. And the argument they make is, well, you see, we're not going to have a stranded asset. It will be useful. It won't be high-speed rail, it will be useful. But the bond funds are for high-speed rail. They're not to build track for Amtrak. They're to build a high-speed rail system. If you built that initial segment, initial construction segment, and you couldn't go further, and you ended up handing it over to Amtrak, you would have violated the terms of the bond, because you would not have built a high-speed rail system. And the purpose of these requirements in the funding plan was to make sure that didn't happen. And by violating those purposes, it's violating the Bond Act itself, because it's not assuring the voters, it's not doing what the Bond Act required, and you could end up with something that was in fact in violation. It's as if, in the O'Farrell case, the Board of Supervisors there said, okay, start building and go as far as you can. And if you don't complete it, well, you've done what you could. I don't think that would have been any more in compliance with the Bond Act than basically setting up a contract that allowed them to build 2 miles instead of the 4 that had been promised. If you're complying with the Bond Act, you have to comply with it. If you're starting off building and you can't complete, or you don't know if you can complete what you set out to do, you're not complying. And I think that's what's happening here.